We're looking now at the case of Cherry versus McCall. It's a Texas Court of Appeals case from 2004. It's a 138 Southwest 3rd, 35. It seems that the Cherrys, who were the plaintiffs, and here the appellants, bought a home from the McCalls. The McCalls were the defendants at trial, and here they're the appellees. And apparently there was one or more sealed up rooms, walled in room in the basement, it says. And inside the wall in this room was junk, crud, left over from construction, including plumbing fixtures, sinks, bathtubs, toilets, rocks, etc. And what they said, the Cherrys, well, we didn't buy that home. That is, we didn't contract with the McCalls to sell us a home with these hidden rooms full of crud. They contracted with us to sell us this nice home we thought we were buying. So they allege a breach of contract, and they say the walled-in rooms, I think it's rooms really, constitute a mutual mistake justifying rescission. I think it's rooms because a little later in the opinion, the court refers to a number of hidden rooms. Well, the Cherrys contracted to buy the place as is, and the trial court ruled that as is means that the Cherrys had taken the entire risk as to the quality of the property and the resulting loss. So they argue on appeal that their lack of sophistication regarding the as-is provision puts them in a different position than if they had not had that lack of sophistication. And they say that the as-is clause is unenforceable given the totality of the circumstances. Okay. This court says, we disagree, politely. There is no evidence that the Cherrys and McCalls entered into the contract from an unequal bargaining position, or that the contract was not made at arm's length, or that the as-is provision was not freely negotiated. Mrs. Cherry, in her deposition, even confirmed that she agreed to purchase the property in its current condition and, quote, accepted the risk, close quote. Well, they cannot, as a matter of law, prevail on their breach of contract claim. And then the court turns to an earlier case in Texas, the Demonet versus Pera case. In case you're going to look it up, it's at 877 Southwest 2nd 352. It's a Texas appellate case, 1994. And that case held that in order to be entitled to a declaratory judgment that the contract was made under a mutual mistake, the Cherrys would have to prove 1, a mistake of fact, 2, held mutually by the parties, 3, which materially affects the agreed upon exchange. And that is precisely what Section 154 of the restatement adds or includes. And that says, 154 says, a party bears the risk of mistake when the risk is allocated to him by the agreement, or where he knowingly treats his limited knowledge of the facts surrounding the mistake as sufficient. I think that's what the Cherrys did, both of those in this case. So the risk of mistake here was allocated to the Cherrys by agreement when they contracted to accept the property in its current condition. Accordingly, their claim of mutual mistake fails as a matter of law. Then they say, well, we didn't achieve a meeting of the minds with the McCalls because we thought they were selling us one thing and it turned out to be another. Politely, the Court of Appeals says, we disagree. Mrs. Cherry confirmed in her depo that she agreed to purchase the property in its current condition. She accepted the risk. Thus, the evidence confirms that a meeting of the minds did take place. Both parties agreed to place the risk of any unknown defects on the Cherries. Well, that pretty much wraps that case up. The court at the end says, because the McCalls proved as a matter of law that the Cherries are not entitled to a declaratory judgment on either breach of contract or mutual mistake, we hold that the trial court did not err in granting summary judgment in favor of the McCalls. And they affirmed the judgment of the trial court. Remember that summary judgment requires that there be no triable issues of fact. And in this case, there were no triable issues of fact because, as a matter of law, especially after we have established by Mrs. Cherry's deposition testimony that they agreed on her and her husband accepting the risk, and they agreed that enough to have a meeting of the minds because the Cherries agreed to purchase the property in its current condition. No question of fact left. It's a question of law. The question of law is resolved. The Cherries lose again.